Okay, hello everyone. It is just afternoon on Monday in the month of May, and we're here again for our Monday noon series of unemployment law information and question and answer. My name is Joe Schaefer. I'm an attorney with the law firm of McDonald, Hogue, and Bayless. I do employment law, but I also sit as the president of the board of the Unemployment Law Project. So that's my role today. We have with us today John Tierpak, our executive director, and Ann Paxton, one of our staff attorneys, who are going to do their best to answer your questions. Before we begin, though, we like to start each week with just a brief overview of terminology, just so everybody's on the same page and can follow along. In the normal case, and of course this is not normal times, but ordinarily we do have three basic scenarios. Either someone is laid off, in which case benefits are nearly automatic. The second situation is somebody has quit voluntarily. In that situation, the employee has the burden to show that they quit for a good cause reason as defined by the statute. In the second and third scenario is called a termination for misconduct. And in that situation, the employer must show, in order to disqualify the employee, that a person was terminated for misconduct. Again, something that's defined in the statute, and that's the employer's burden. So as we're talking, it will become clear that in ordinary circumstances, one would rather be terminated for a reason related to COVID, because that's almost never misconduct, and you should be getting unemployment benefits. Whereas if you quit voluntarily, you will have to do the proving of meeting the burden of proof that you quit for a good cause reason. So that's the basic overview of terminology. But now we really wanted to turn to our weekly update. This is an area of the law, and our government seems to be moving each week. There are changes, and so I'll turn this over to John and Ann to give us a little bit of summary about what's new.
Okay, let's see here. Basically, we are I want to give a little background here about Unemployment Law Project. We provide low-cost representation, free advice. We've done hundreds of hearings. Last year, we will expect to do more coming out. One of the biggest challenges we're seeing is these new rules coming in, because never before have independent contractors, self-employed, Uber drivers been covered by the unemployment system. There are some changes to the basics, like basically in the traditional unemployment, the regular unemployment, you have to have a minimum of 680 hours in your base year. If you don't have the 680 in the base year, you may qualify for new programs, and also traditionally a claim is only 26 weeks. There have been extensions during periods of high unemployment, and there is an extension that is added now. So we've already talked about layoff, voluntary quit, termination. And now I'd like to open this to Ann to talk about what has been passed recently due to the COVID pandemic.
Thanks, John. So there have been a number of expansions of eligibility for benefits. And I wanted to talk a little bit first about what has been happening with the federal changes, just briefly, because most of our questions are gravitating more towards specific applications right now. But the main program that the Federal CARES Act has added is pandemic unemployment assistance. And that adds eligibility for gig workers, for independent contractors, for part-time workers, and for people with less than 680 hours in the previous year. Pandemic unemployment compensation adds the extension of 13 extra weeks of benefits. So there are now available up to 39 weeks of benefits, about 9 months. And the benefit floor for receiving pandemic unemployment assistance is $235 per week, which is half of Washington's average benefit. When they are trying to verify some information about your wage background, they will generally, if you qualify for pandemic unemployment assistance, they will generally give you the 235 minimum plus the pandemic unemployment compensation, PUC, which is the extra $600 per week. And that is in effect from March 29th through July 31st. So what changes have occurred in Washington State in addition to that, but kind of in conjunction with it, because parts of these are paid for by under the Federal CARES Act by the federal government. For one thing, job search requirements have been suspended. So that means when you answer, normally you have to answer questions about what your job search consisted of during the week, how many contacts did you make, and where did you go. That's been suspended for now because of the COVID crisis. The waiting week has been suspended. That's normally what you would have to, for a week that you would have to forego benefits the first week of your eligibility, just because that's the way the law has been set up. And in addition, the state has added standby and shared work programs, expanding those to part-time workers and extending them in time so that they are available for up to 12 weeks. So I wanted to move into, since most of our questions, as I say, have been dealing with people's specific situations, there seems to be actually quite a lot of understanding out there about what PUA means and what PUC means. But please stop me if you need clarification. So I wanted to start to kind of walk through what the main questions have been in the last week or two. And the number one hit of all time is, what is the Employment Security Department doing to answer calls and speed claims processing? Because people are still having so much trouble getting through. When they do get through, they get questions they don't understand and perhaps answer incorrectly. Their claim gets sent who knows where, and then it gets stuck and they don't get any benefits. So it's a very frustrating process. And I wanted to just update you on what the ESD is saying about how they're responding. They say they are getting fewer calls with questions and more specific claims issues, very specific things that people have to be resolved. And they're focusing on assisting people with navigation for, especially for people who haven't been able to apply or who have access issues or are challenged to in filing their weekly claims. Their primary focus now is adjudication, and that is the process that happens when you filled out all the forms and there is some snag that doesn't comply with the checklist that they have at ESD and will delay your claim. So it gets diverted into the adjudication phase. They're trying to tighten that up, and they have an ambitious program called 100%, Operation 100%, that is focused on the approximately 57,000 claimants who are stuck in that adjudication phase. And their timeline, they gave us a timeline for catching up that they're aiming at. By May 22nd, they expect to have reduced the adjudication queue substantially. By June 16th, their aim is to get all claims through the adjudication queue. And this week, they're going to be posting ongoing progress towards their milestones. The kinds of problems they're encountering that put people into adjudication is that perhaps their benefits have been exhausted. Perhaps there's a difference between the wages they're reporting and what their employer is reporting. Perhaps they were fired for cause for misconduct, and they don't have a reason relating to the COVID pandemic for not working. Something else that adds people to the queue is that they're qualified and they're receiving aid, they're filing weekly claims, and then they say they're no longer able and available to work. That will cause an immediate problem. And we've also encountered a lot of issues with people having said they're on standby or somehow suspended from work, meaning their employer has suspended operations, and that's interpreted differently from what they mean it. And we've in fact, we've been advising people not to say they're on standby, but rather to say that they've been laid off, because that will send them down a much more defined pathway than using the term standby. So they do have, just in terms of specific steps you can take to speed up the implementation, that the speeding up of the claims process. They have asked us to make sure to tell people to please answer your phone when you get a call back from ESD when they're trying to go through the adjudication process and have some questions to ask you. Unfortunately, if they return your call and you don't, and there's going to be no caller ID, so a lot of people won't pick it up. But unfortunately, if you don't pick up the phone, it will send you to the back of the queue. And we would like to have this changed, but that's what they're doing right now. The other thing I can give you that as a quick measure that will help speed your processing of your claim, and that is to file your 2019 taxes if you haven't done it yet. And those will use those documents to upload to ESD. But any documentation you have will probably help speed up the process. So let me talk a little bit about the second question here. Does the job search suspension mean that I don't have to be available to work? Now, most of us know that the requirements for receiving benefits include not only that you have to be able to work, but also that you're available for work and actively seeking work. The job search suspension rule under the emergency rules, it holds that you do not have to make those 3 contacts a week. You do not have to demonstrate that you're making them, but you still have to be available for work. So what does that mean? As Commissioner Levine says, the job search requirement suspension does not mean it's job optional. So under the Pandemic Unemployment Assistance, PUA program, it's very clear that under the circumstances that allow you to be on the PUA, if you're if you decline a job, you're going to run into trouble. You do have to say, when asked if you've declined a job, you have to say that if you have, and you will have the opportunity on the electronic form to explain why. Then if you are not, if you are denied benefits, if you're denied regular benefits, you can be eligible for a PUA, and that job search requirement is waived for everyone. But again, you must be able and available to work. And on regular benefits, there's absolutely no way around this. When you're on PUA, there's some limited exceptions because of the COVID crisis. For example, if your children's school has closed, then you may be able to, you can say that I'm not available to work right now if that's because of COVID. Some people have said that the job search questions are still appearing on their weekly claim form, but they are optional, and the ESD has said it is not a condition if you answer that you have not done a job search. It's not a condition that would make you lose access to benefits. So let me just say a couple of words about this issue of having no hours or wages in the last year, because this has arisen with several claimants who've asked us, can they be eligible under the federal program? It says if you have less than 680 hours, and the initial understanding and explanation was that you only needed to be eligible for $1 of benefits. But in fact, you can get PUA if you have no hours or wages in the last year. If you have 0 hours in your base year, you can apply for PUA. This is after you've been denied regular benefits, and then qualify. And you would get the minimum $235 plus $600 a week, as long as you continue to certify that this is because of the impact of COVID. So it must be COVID related. So if you start your application and say you have no wages or hours on file, it should take you straight to the PUA application. And the key is to remember, under PUA, you are unemployed, partially unemployed, or unavailable because of a COVID-related reason. And there's no separate application for the PUC, Pandemic Unemployment Compensation, which is the $600 a week. If you're authorized for benefits, that is regular benefits or benefits under PUA, there's no separate application. It is automatically layered on top. So just a couple more questions and then we'll open it up to your questions for today. Should I go back to work if the workplace is not safe? This is something that ESD has been definite about, and so have we. That if there is an unsafe workplace, you are not expected to return to work there, although you are expected to accept a job in general if it is suitable work. But unsafe workplace is not considered suitable, and Commissioner Levine has said that ESD is working together with the Labor and Industries Department and its guidelines on what is considered a healthy workplace. And another option, of course, is if you have access to telework. You're expected to take that because the idea is that that would be not considered an unsafe workplace. And then last one, how much income can I make without losing benefits? Well, we've got several questions about this because every week you claim benefits, you're asked the question, did you work and did you perform any work this week, whether or not you received pay? So it's a little bit complicated answering the question about reporting that actual money if you have not gotten the money yet, because obviously that's a situation where you are in need of benefits. But that's more complicated. But the issue is, can you, how much income can you make before your benefits under PUA are suspended? And that's important under PUA because once that happens, once you return to zero benefits, then you also lose the PUC, the $600 per week. So the secret is to go to the earnings deduction chart, which is on the Employment Security Department website. You can also contact us and I'll send it to you. But that lists all the gross earnings levels that you can make and the deduction that each one will lead to from your benefit amount. So it's very simple. You take your gross earnings, you basically take $1 off of $5 off of those. 75% of that is going to be the earnings deduction from your benefit amount. And once you get below, once that earnings deduction takes place and you are below zero, then you cannot continue getting benefits. So just to give you an example, if your benefit amount is $165, you can make up to $223 before you will go to a zero benefit status. So a lot of other news developments, but I would like to turn it over to questions for anyone to open it up. But John, did you have anything you wanted to add on safe workplace or any of those other issues?
The safe workplace is the big issue right now, and because a lot of employers are opening up, and there's not an easy answer to say what is safe and what is unsafe under the law. There's obviously going to be differences of opinion. And I think that what would be good for people to look at reliable websites, reliable sources of information about what the safety standards are. That would be good. And also, if your reason for not returning is due to a medical issue of yourself or a close family member, that should be something that if you can get documentation of that, that would be helpful. And I say helpful because often with unemployment, whether it's an application or a hearing, your statement can establish something, but of course it's always better to have documentation, whether you're dealing with an issue about accepting a new job or whether it's a reason why you left a job. It's good to have that written medical documentation if that is an issue. But I would say that everyone should be concerned about safety, and that they should not just rely on an employer's word that it is safe, because a lot of these employers are, well, some of these employers, I should say, may have opinions that are not based on science.
Okay, everybody, I think we're going to get onto our question board. We have quite a few queued up. As usual, I think we probably can say we probably won't get to all of these, but or keep giving me your questions just in case we move faster than expected. Just to let everyone know, this session is being recorded, and so if there's an answer that you hear that you like, but maybe you missed and you want to go back and listen to it again, the recording will be up on our website after the session. So keep your questions coming. First question is a person who says that they're off of work because of being high risk. Sounds like they work as a caregiver, and they were approved for regular unemployment, but they want to know what happens if they go back to work part-time, and then what would happen if we see an increase in cases because things are opening up and they have to stop working again because they're high risk. They really want to go back to work, but fear that they would lose unemployment totally if they have to stop working again. Can you give some guidance there?
Well, I think on the safety issue, again, look into the work conditions and don't put yourself into an unsafe work condition. And then Anne just spoke to the issue of how much income can be earned while keeping benefits. And
Right. Yeah. So
to that.
the earnings deduction chart will tell you how much part-time income, and many people are in this situation, especially because people have been added that have never gotten benefits before. That is, people who are independent contractors. Many of them have a couple $300 coming in a week and are worried if that will mean that they lose all of their benefits. So there is a way to do that to make sure you don't fall in that category.
How does one retroactively, I guess, kind of rectify an unemployment claim that has errors, including the start date of the claim? Is there a way to go back and kind of fix things?
Well, during normal times, you could call the 800 number and reach a person. That's been a problem for many thousands of people right now. My understanding is that you can send messages through the portal. That's one thing that can be done. The big problem is the delay in claims. There are not enough workers hired processing them due to the incredible demand. Some people have hung on and called the 800 number during odd times of the day when it's been lesser traffic, and has some pointers on that. Also, I've advised some people to contact their state senator and state representatives to perhaps intervene in their case, but also to just let them know that there needs to be more funding there. Anne, could you add to that on the what times of day are best to call?
Okay, I wanted to just add about what you need to show if you're not sure about your start date or your end date. They ask you to be definite about your last day of employment, but you can estimate the earlier ones. Estimated start dates are okay, but the last date of your work or your self-employment should be accurate. And in terms of the best times to call, they're saying, please don't call early in the week. Sunday is not a good day. They're trying to reserve the early parts of the week when you file for claims for people who are in dire straits. If you have more of a regular claim without a lot of issues, they ask that you file later in the week. You'll have a better chance of getting through without problems as well. Not in the early morning. The important thing to remember is that the benefits are retroactive. You have the rest of the week to file your claim. It doesn't have to go in on Sunday, so it can go up through Saturday.
Great. Someone has a question about getting the actual money. That sounds like they've enrolled, they've gotten a response about the amount they should be receiving, but they haven't been funded yet. Can you give an idea of how long that might take, and then what they should do if they keep on receiving no money?
Yeah, unfortunately, I don't have a really great answer on that. They're very, very overwhelmed. They say, for example, when I say that it goes to adjudication, their goal is to get the adjudication time down to the normal length of time, which is 21 days. So they're not operating on what you call a tight time frame. One way to get benefits faster, that, however, is to use direct deposit, because they say that can take 24 to 36 hours as opposed to 7 to 10 days, which it might take if a check has to be written.
Great. And up in the chat, we're seeing that we've placed some information about how to get in touch with your legislator here in Washington, and it's very important that your legislator and the governor hear from you if you're having these kind of troubles, because we need to put pressure on the elected officials to increase funding to hire more people to solve these problems. Next question. Some people are still having ongoing problems applying if they're drawing a pension. How about that one? Any ideas?
This is a big issue. For reasons I don't agree with, they have rules that have been in place for years that if you're drawing a regular pension, that income, if it was funded or partially funded by an employer, is deducted from your unemployment. So let's say you get $1,000 a month from an employer paid pension. Your regular unemployment would have been, let's say, $500 a week. They would prorate that over the month and deduct about $250 according to the formula, count that 250 against it. So the problem for some people is that these pensions really put them out of the claiming, if that income is very high. There are some people who've been long-term employees who are getting a pension and who are still working, who unfortunately might be cut out of the unemployment system. One of the confusions, though, has been about 401ks and 403bs, because the question is very poorly worded. So a lot of people think they can't get benefits because they have a 401k or 403b, and I've talked to a few people who have cashed out their retirement in a panic to qualify for unemployment. And I would advise people not to do that, that if it's a 401k, exactly that type of thing, that is not something that is an income that you are receiving. That's in a separate account for you for the future. But there have been a lot of problems with that. And people can contact us individually at Unemployment Law Project. Some of these cases are very complicated, very convoluted, with a lot of multiple issues. So we're giving what we think is the best sort of general information right now, but everyone is welcome to contact our office for help.
Okay, and if we could, let's put our phone number up in the chat. If we could, we'll get everybody that information right here. Next question, somebody talking about, medical reasons for not going into work. What kind of information is required on a doctor's letter if you're high risk because of age and a medical condition? And are both barriers to working necessary to not have to go back to work, or is age sufficient? What do you recommend there?
Well, I would recommend that the doctor's letter address the workplace itself and the condition and age of the person and the risk. So, to say, let's say a person over 65 who has respiratory issues is being asked to go into a, let's say, a medical facility. It would be, the doctor's letter should talk about the risk of the environment posed by that environment, or let's say it's a warehouse with people working together in close proximity without protective gear. That would be a situation, and then also discuss what that person's particular medical issues or their family members. And we've all heard over the news what the risk factors are. I've heard some different things over the years, over the months, like about what age is the risk.
I think we might have just lost your audio, John.
I'm back.
Okay.
You are back
Am I
on.
back? So it's good to keep a copy of anything you submit to anyone.
So yeah, and I can just add the documentation that you need under the eligibility for guidelines for under COVID is somewhat less rigorous, because the questions that are being asked, for example, are you showing symptoms of COVID and are either waiting for results of a test or seeking medical attention? So it is not saying you have to have a doctor's note. Are you at high risk and a medical provider has told you to stay home? That's a place where you would probably want to note. Are you caring for a family member or dependent who has COVID? Again, but do you have a family member or dependent who is showing symptoms of COVID and is seeking medical attention? So you see there's a lot of stages before actually getting a documented illness by a medical provider, where you should be considered eligible according to the guidelines they're giving us.
And I would also add there that you may want to try, if your job is the kind of job where some kind of accommodation could be reasonably afforded to address these issues, that you would have some rights under disability law and the family medical leave laws to try to get that kind of accommodation put in place. Next question is somebody who sounds like they have a family member, a son who lost their job as a sports reporter in Idaho. They live in Washington, but they have to file in Idaho. He filed online about 5 weeks ago, got nothing, attempted to get in touch, can't do it. Do you have any ideas for them? I realize it's an Idaho question, but is it possible for that person to file in Washington now?
No, they should file in the state where their wages were paid. To attempt to turn it into a Washington claim would be such a long, hard, and probably a losing fight that I would not recommend. So
Okay.
the
And then also, I'm sorry to interrupt, John, but I kind of turned the question to that, but do you have any thoughts for any other way to contact Idaho unemployment, or are you familiar with that?
Yes, on our website, on the Unemployment Law Project website, we have referrals under resources, and we have listed 50 state legal resources. So Idaho should be there for the Iowa Legal Services. I can't remember exactly the name right now for Idaho's legal aid, and I think the advice of contacting your state representatives, people in your state. I don't know if it's a state assembly or house or whatever, to contact your public officials about that, and that the $600 that's added to benefits is a federal issue, so that should be covered there.
Okay, somebody writes in that there still seems to be problems with people being rejected with no reasons given. Is that something you're familiar with, and what can you add on that?
All too common, and under standard due process law, you should be notified of a denial in a timely manner and given appeal rights. And you should be notified why you're being denied and what law is being used to deny your claim. That's not being done. Again, we've advised people to request hearings. Also, again, contacting legislators. It's a very difficult time for them with the overwhelming demand, but they are not following basic procedures right now.
Okay, let me see. So what should people do if they're still being denied unemployment when they were laid off because of COVID? And also, should people click on standby if they're applying for the pandemic unemployment?
Standby, well, I'd like Ann to sort of touch on this. The standby rule has been around for a long time, and it allows somebody not to have to search for work because they have a temporary layoff. And
John, we lost you again.
John, we lost your audio again.
Job search being relieved or as optional in early March, there's not as much of a concern whether you're on standby or regular benefits. And can you touch on that as well?
So there's only one benefit to claiming standby status, and that is suspension of job search. So since that is not an issue now, job search has already been suspended. We have tended to advise that you just say you've been laid off, because most people don't know when their employer is going to be opening up, because our lockdowns keep getting extended. We can't guarantee any particular time frame when all of these businesses are going to be starting up again. So layoff is a safe option, and it is not incorrect.
Okay, very good. I think we covered this a bit in the intro, but maybe we can address this more specifically. New problem coming from local IATSE Local 15 workers. They've been directed here and in other seminars that they do not need to be available for work to collect benefits, but many of the members have done so and had their claim been denied. Now they're hearing that they do need to be available. So what's the best course of action for these workers?
I think the clarification here is, well, again, they should contact ESD to correct, but the problem is this sort of distinction between available and searching, and I spoke about it before, like in terms of you are not required to search for work, but it's good to say that you're available to work, even though there's no work now anyway.
Yeah, they're never saying you are not available for work, except under COVID, there are exceptions to that. For example, you're not available for work if you're home sick with COVID. You don't have to say you're available in that case, and that does qualify as an exception for availability under the PUA guidelines. So, but in general, you must say you're available to work. That has not been suspended. And in fact, if you decline a job that is considered suitable work and it meets the safety guidelines, you're going to have to account for that, and it may interfere with your benefits. So job search suspension does not mean availability suspension. In general, that still applies, except for those certain circumstances under COVID.
Okay, great. So here's somebody who, it sounds like they've gotten reemployed. They say they're actually getting compensated now. Should they withdraw their claim or simply not file weekly claims? What do you recommend there?
Here's a question we've been getting over the years at Unemployment Law Project, and without the crystal ball, I generally have said to people, if you're back at a new job and your income's going to be more than your weekly unemployment amount would be, and there's no chance you'll be getting unemployment, if you're claiming, and this job is going to be indefinite, it might be safe to close the claim or end the claim. However, many people are in unstable situations, and if the job may be temporary or the income might fluctuate radically, it doesn't hurt to keep it open and just claim that income, because then if a week comes that you're either have extremely low hours or they just lay you off, it's much easier to just continue the claim than it is to try to reopen, reapply.
Okay. Question about traditional, or actually question about royalty income. So it sounds like non-work related compensation. Do you need, under both traditional and the PUA, to report royalty income on your weekly claim?
My understanding is, and please, Anne, I hope you can address this a little bit if you have anything additional, is that you report income the week that it is earned. So like by royalty income, for example, if you're a musician and you write and perform a song, record the song, you would report that what income you earned that week when you did the, let's say, the recording performance. But anything you did last year and that came through, that would not be income that was earned in a current week. And is
Yes,
there anything else you want to add to that?
So yes, ESD has told us this is actually a little bit more complicated when you're trying to figure out what you should report to them when you don't have the money coming in, but you have done the work. So if you are working and you won't receive income until a later date, ESDA said, yes, this is complicated. So you have to report the work hours during the week you did the work. You can report 0 income now and then contact ESD later with the actual amount earned. Or you can report an approximate dollar amount now and then contact ESD later if it is different, and they will make an adjustment to your benefits. It's theoretically you could have an overpayment or get extra benefits that you weren't planning on. But in terms of royalties, yes, since that it was past income, I think what John is saying is correct.
Very good. Do all PUA claims only receive the benefit floor of $235 a week, regardless of your submitted date via requested Schedule C, and other documentation? And then the person asks subsequently, I thought this was calculated by your self-employment net earnings.
So yes, the earnings for obviously for people on wages and salaries, that is what is called gross income. It's very confusing. They refer to this as gross earnings, but when it becomes to people who are self-employed, and remember they have not granted benefits to this cohort before, that is net income. That's been defined under the disaster assistance rules that have been around and are referenced in the CARES Act. So it is net income. I'm not sure about Schedule C, but it's your net self-employment income, not your gross.
Very good. Here's a good question. I work at a gym that's been closed due to COVID-19. Under the governor's phase plan, gyms are not set to open until phase 3. My gym has decided to open under protest starting this week. I am in a high-risk category due to my asthma, and I'm uncomfortable going back to work knowing that we are opening in direct protest to the governor's order. I'm currently on unemployment, but since they have called me back to work, will I be disqualified from unemployment if I refuse to go back to work right now?
You should not be. It would be good to just notify the employer very politely that you cannot return until situation changes. There's a chance they will terminate your employment, but I would argue that that would not be misconduct to refuse to go into an unsafe situation. Keep claiming unemployment. They ask you a weekly question about if you refused any work. You would want to answer yes and then give the reasons, and that should go well. If there's a dispute or a denial and you have to request a hearing, please request a hearing right away and contact Unemployment Law Project when you get a hearing date.
I would also recommend, as an employment lawyer, this issue has come up in my bar, and if you were to actually get terminated for refusing to come back to work in a situation where the governor has ordered the business to close, you would most likely have a claim for what's called wrongful termination in violation of public policy. So I would recommend, if you are terminated, to seek advice from an employment lawyer.
And see the eligibility checker at the Employment Security Department website to get, there are many categories that you could fall in, especially this person said they were in high risk. You should not be required to return to work. What they don't want to hear is, I quit my job for reasons unrelated to COVID. I am an essential worker, not high risk, and my workplace has met the safety guidelines, but I'm too afraid to work. You do not want to try that, because what you want to do is qualify as a high-risk person who's been advised to stay away from that workplace.
Very good, and everybody should check out the chat now. We've got resources coming up. WELA is the organization, Washington Employment Lawyers Association is where you can find an employment lawyer. We've also got the link to the eligibility checker up there now. Next question, if you work enough and receive enough compensation that you get no unemployment payment in a specific week based on your weekly claim, do you also not receive the PUC for that week?
Yeah, well, if you're receiving money under PUA or regular benefits. If you have zero benefits, you do not qualify for PUC.
Next question, the person's been unemployed since March 25th and still haven't received unemployment. 2 of their cases say pending and they don't know what else to do. Any thoughts, Governor's office?
Well, yes, I mean, again, try the 800 number at a time of the week. It might be less busy. Yeah, people can file for appeals, but I don't know if that would necessarily work in this case, if they are eventually being denied or not. Again, contact state legislators, and I think that a lot of these are individual situations, and people are welcome to contact our office.
Very good. Next question is one we've had in prior weeks for sure. Is standby the same thing as furlough?
You know what? I will give a longer answer here, just because I think it requires because standby can be used in a generic sense of the word. You're on standby from a job, but it's also used as a very specific term of eligibility in the unemployment system. And there's been a lot of confusion because people have been told by their employer in a casual way, you're on furlough, you're on standby. And then when they apply for benefits, they say you're denied, which makes no sense. Well, the problem was that employer didn't notify the unemployment office. But since the job search requirement has been removed, temporarily at least, there's no real difference of being on standby, layoff, or furlough. Furlough could be a short time, it could be a long time. Furlough means you will be going back, as well as standby, you will be going back, and a layoff can be permanent, it could be temporary. The words are often used interchangeably, but I think sometimes there's been some confusion created because of the word standby being used, whether it refers to a specific program within ESD or a specific rule within employment security, or whether it is simply, your employer intending to bring you back in the future.
Very good. Next question is one that involves the intersection between unemployment benefits and the PPP. This person was approved for unemployment benefits based on a base year starting October 2018, when they were working 3 jobs, 1 full-time with Tacoma School District and 2 part-time jobs. They've been getting unemployment benefits now for the past 4 weeks. But last week, one of the part-time employers got the PPP loan and wants to pay for 5 hours a week for the next 8 weeks. If they accept this money, about $100 a week, will that end all their unemployment payments? Or if they quit this part-time job now, will they be disqualified for current unemployment benefits?
Reporting 5 hours a week, unless it's an incredibly high income, which I'm assuming it's not.
They say $100 a week.
Yeah, that should not kick them off. In general, I'm speaking in terms of general terms. Again, individual cases and results might vary, so a person can contact our office for specific advice. But as far as what was part 2 of the question?
If they quit the part-time job now, would they be DQ'd?
Ooh, okay. Quitting, the laws regarding voluntary quit are still in place. So there's a list of 11 reasons that might constitute good cause for quitting. Be very careful here, because the state unemployment system looks at you as a person, not in terms of a particular job. And over the years, I've talked to many people who quit a job. Maybe they had an unemployment claim open, they took another job, they quit that. They thought they could go back to claim unemployment, and they couldn't because there wasn't enough good reason to quit the first one, quit the second one. It gets very confusing. So this is a case with multiple employers. There's no reason to quit. Unless there's a compelling, this is why this is probably more suitable for some kind of individual consult, because there may be reasons that workplace. I'm assuming the person's quitting just to kind of be done with that relationship. But if there are certain compelling reasons fitting into certain categories that may qualify as good cause for quitting, it's a very complicated issue because there are 11 reasons listed. And I don't think we want to go through each of the 11 reasons why you could quit and get unemployment right now. You know, here, but I think my bottom line is to be very, very careful before you quit. Get specific advice, not general advice about, and really look at what the law is in the unemployment statute under RCW Title 50 of what are the reasons for good cause for quitting. Because with one of the biggest problems we've seen over the years is people will look at the list and they'll say, oh, you know, reason number 5 fits my situation, and then they quit. Then they find out that reason number 5 had, you know, 5 different other rules attached to it, which they did not fulfill. That's always the problem with the simple answer. Yes, a person may quit and get unemployment for medical reasons, but that doesn't mean any person with a medical reason in all circumstances will automatically get unemployment. And that's why we're here as Unemployment Law Project to try to give people the best possible advice in their individual cases.
Very
And
good.
there
And
are-
correct me if I'm wrong, John, but I think it's always problematic to say that your good cause is because it would decrease your benefit amount. Am I right?
Absolutely.
More than problematic.
More than problematic. Yeah, for years we've had cases of people who told their employer they were quitting to get unemployment, and every one of them has failed.
Very good. Who is it that determines if a workplace is unsafe for an employee to return to?
Well, in a perfect world, we would have, you know, full-time inspectors stationed everywhere. I think that it would be good to get reliable information from reliable sources, Department of Health or the governor's office, other, I'm not thinking, Ann, could you think of any other, and Joe, any other like reputable sources of information?
We've
Labor
been
and
told,
industries, labor and industries, for example.
we've been told that Labor and Industries has specific guidelines for a safe workplace. But obviously, if there's requirements that are citywide or countywide, those have to be complied with. Some areas of the country, those are starting to include wearing masks, for example. That's still kind of rare, but other things like 6 feet guidelines, that's not rare. So I would say I would consult Labor and Industries first.
I also know there's another government agency called the Division of Occupational Safety and Health, or DOSH. It's the state equivalent of OSHA, and that's another organization that can field workplace safety complaints. Next question. We have several PUA claims that have been filed and reflect that they are submitted in the online activity, but the PUA claim is not showing up in the e-services dashboard. There's also no notice of additional information needed. Any advice on how to proceed before calling the question line?
Well, again, this is a problem we've been seeing a lot with people putting in information and it's disappearing. It's really hard to say what it is. I, again, would urge people to call, try to talk to a person. When you do talk to a person, note who you're talking to when you're talking to them, just to and make notes about that, just to figure out what's going on. It's hard to say about requesting a hearing at this point. Perhaps contacting your state legislatures may get somebody in that office to contact ESD to kind of give you some kind of answer. And any other thoughts?
Yeah. They have said, the commissioner did say they prefer to hear about problems from people who are out there, the claimants. If you're having problems like this is kind of it sounds like a glitch of some kind. and they are inviting people to let them know if you've got some kind of technical issue. That would certainly be something they could easily look into. It's not a policy issue. So I would encourage you to write to them and say that you've got this problem.
And write to them through the portal.
Well, you can send a message through the portal. I can give you an address that they might get back to you. I can't promise that because they're flooded with emails, but I'll have to get back to people on that.
Okay, very good. Next person had 2 jobs. They work for a school district full-time and part-time in a restaurant, but the restaurant's closed. I tried to apply for unemployment, but didn't get any money. But I lost 50% of my income when the restaurant closed. Any information that you can get there?
Well, again, it depends on the income. So losing a job sort of gets you into the gate to apply, but then there's always the question of what is your income now? And I'll just, since I don't know the details here, I'll just make up an example. What if the job that the person currently has pays a substantial income that would put them way over income limits to get an unemployment claim? Then they would not qualify, even if their income is cut. And like, for example, if during normal times, if somebody's income was, let's say, 120,000 a year, and it was cut in half, to 60,000 a year, and they kept working. They decided to keep working, and they opened up an unemployment claim and reported their income. They would be reporting over $1,000 a week of income, and that would not qualify them for unemployment. So a lot of the system is antiquated because it caps benefits at certain levels. And even with the extra $600 now, many people are still going to be out, even if their income puts them over. I've been advocating for years to increase the maximum benefit amounts to be more in tune with what a lost wages or lost salary would be. But right now it's capped at certain amounts.
So, and just to reiterate, under the PUA, if you are partially unemployed due to COVID issues, you are eligible for benefits, but you are, in order to find out whether you will have any net income from obtaining those benefits, given what your income is, you need to consult an earnings deduction chart. So several people have asked us about this because they have a drop in income, but they still have some part-time income. So the same thing applies there. Go to the earnings deduction chart.
And this goes back to my point about the state unemployment office looks at you as a person, not only the individual job. For when I got started in this work a long time ago, I always assumed that any unemployment claim was related to only a specific job, and that even if you had 3 jobs and lost one, you could still get unemployment from the one you lost. And I found out soon enough that if you were earning a lot of money from those 2 other jobs that put you over income amounts, you would not be eligible for anything. And as unfair as that sounds, that's the way it is now, but I would like to see that change someday.
Very good. Well, that brings us to the end of our hour. I know that there are still questions that are pending, and we apologize that we couldn't get to everybody's question today. We are here every Monday at noon, but if you need a more urgent response, please do call the Unemployment Law Project. There's numbers in the chat, 206-441-9178, or toll free at 1-888-441-9178. We thank everybody for your participation. Please do call the Unemployment Law Project. We've been very fortunate to be able to staff up during this time in order to be able to answer your questions and help you with any claims that you might have. Until next week, thank you very much.
Thank you.